Hello? Hello? Credit to SC, ಇದು 8th additional ರೂರಲ್ ಕೋರ್ಟ್. ಅದೇ ನಮ್ಮ ಲೇಟೆಸ್ಟ್ ರೂಮ್ ಇಂತ ಮುಂದೆ ಹೋದ್ರೆ ಲೆಫ್ಟ್ ಸೈಡ್ ಅಂತ 92 ಪಕ್ಕದಲ್ಲೇ ಇದೆಯಲ್ಲ ಬಸವರಾಜ್. ಹ್ಮ್ ಹ್ಮ್ ಹಾ ಕರೆಕ್ಟ್. ಹೌದು ಹೌದು. ಅಲ್ಲೇ ಇರುತ್ತೆ ಕೋರ್ಟಲ್ಲೇ, ಮೊನ್ನೆನೇ ಇದ್ದಿತ್ತು. ಹೌದು. ಓಕೆ. Hello, court officer. Hello, hello.
2 weeks time allowed to file to comply, my lord.
2 weeks preemptory, right?
Yes,
Here
ma'am.
all weeks preemptory.
3
Weeks preemptory.
Number 4, government advocate.
Weeks preemptory. 3 weeks preemptory.
Number 5,
1 week's time allowed for the respondent. I'm sorry, my lord.
Pandit, Vinay Vaiti.
Dismissal.
Serial number 5.
Yes, my lord.
Offer dismissal.
My lord heard this matter on the last occasion and directed the matter to be posted for admission on hearing. My lord, I'll have to complain on small corrections.
What memo for disposal? What memo for disposal has been filed?
My lord, this appeal filed against the order of CPC, my lord, WP CPC, issuance of writ of certiorari. My lord, heard this on the last occasion.
Not maintainable.
No, government has filed. Government has filed.
People heard for some time on last week's appeal.
Oh,
History
yeah.
was
My lord
filed.
said, my lord, for here for admission. I'll just correct that mistake, my lord. A week's time.
You wanted to argue, right? We were there. 226 and 227 both there for appeal. That was the argument. Why do you want it, Jan? Praise
Sorry,
for-
my lord. Today I'm not well, my lord, so I'm doing it through VC. I'm sorry, my lord.
Doesn't look like you are blowing. Huh? You are doesn't look like that you are not well. Huh?
Grateful, my lord.
Pandey, can
Monday.
you make out that he is not well? See on the screen. Can you make out? No. Can you make out that he is not well? That's what we are asking.
Next week, my lord.
Correspondent to this gentleman. This next week.
Grateful.
Undertakes to comply with office obligations within 1 week. Then say this next week.
Grateful.
So what about 1, 3, and 4? Not served. Weeks. Preemptory. It is 6.1. Yes. This
Yeah, acceptance.
has been published. The same is accepted. Then 1 of so who appears 1 of 21? Delay in filing. Reasons assigned duly supported. Even 6 days in filing. Condoned IA. 6.2 also you have to take steps. Take 2 weeks preemptory.
Number 7, Kumar Sanjay.
Translated form for reason assigned. Requirement of filing. The translated copy of annexures is dispensed with in the event IA is allowed. Yes, in view of order. I know the appeal appears to be within limitation, therefore no orders are required to be passed on IA. 2 of 22 same is disposed of. In view of submission made by the for the appellate office of fiction is ignored. List for admission and for consideration of IA 3 of 2022 in the next week.
Number 8,
My lordship, I have taken steps 3 times, my lordship. It is not served. And I have filed the paper publication application also, my lordship. Kindly, the application may be amended.
Not 21. appearance of respondent before the court 15th December 2020. Accordingly, IA 1 of 21 is allowed.
Number 9, Suresh Kumar HR. Number 10,
Weeks preventive.
number 11, Manjulati.
Weeks preventive. 11. Your publication. When have you filed?
It's not very deep.
Not filed.
Place time to file application.
You want time to file application. How much time? Weeks time. Enable him to file an application. Substituted service.
Number 12,
Memo has been filed.
Status.
Taking leave of the court to withdraw the appeal. The memo is taken on record, which accordingly appeal is dismissed as withdrawn.
Number 13, State Administrator, Government Advocate.
Ah. Yes. Objections filed. When will you argue? 15. Next Tuesday. All right. Pleadings in the case are complete. Let the petition be listed for hearing on 15th November 20. Right. Also, what is it? Detention? What did it? Password. Status report filed. Yes, purpose what? Preventive detention. Objection filed. Who is third respondent? But they have denied, right? No.
During the last week, you were two clients of made.
Put 57, 380. Huh? What are you in? He's saying no. Then what to do? You produce it. Acha, he is absconding. They have
What happened to the complaint before the Human Rights Commission?
For offense under section 365 and 34 against.
indeed custody, right?
It's not in judicial custody. Is it? The whereabouts are not known.
Your whereabouts are not known, right? He can only contact you and he is not visible to police. He doesn't appear. So according to
when
you,
is-
he is detention.
Just
So are you in a position to deny this, Mr. Paragraph 6? 8 cases and non-bailable warranty. And the lookout. Why don't you report? I mean, what is this? This is abuse of process. We will send him to jail for doing this. The police itself is unable to trace him and he is absconding and you are filing a petition.
He was security.
His allegation is that police have taken him.
One police was personally presented. We have
But case is pending. You know, something has happened to him after they have taken the
Not filing a rejoinder. So we don't have any ground to disbelieve the stand taken by the government. You have not filed a rejoinder also. And you are admitting that there are 8 cases against you, habitual offender. And so, Mr. File a rejoinder.
Who is this Puneet? His statement. Huh? Allegation is specific against Puneet.
He is not party. Not party.
It's a police officer. No, that merely for the reason that is required in 8 cases means you cannot take him to custody and not like that his whereabouts are not known. There's a specific allegation against you that you have taken him to custody. What happened to this? They have filed a affidavit. If you want to file any rejoinder, you file a rejoinder. File it. Also find out the status before the Human Rights Commission.
How much time? Next week, Learned Counsel for petitioner prays for a short accommodation to enable him to file rejoinder. Just on 16th of November. 16th November. Taking leave of the court taken on record this later on 17 of the same order. For withdrawing the appeal. To do something, you want a liberty with liberty to take recourse to such remedy as may be available to him in court.
Certified.
Certified copy of the impugned order be returned to Learned Counsel for the appellant on subscription thereof by a photocopy. Then memo is taken on record. Appeal is dismissed as withdrawn. 30 years of. Sayukta Karnataka Yumoga edition. Appearance of respondent before this court on 14th December.
About 19,
What date? Plea hearing.
Earlier.
On IA taking into account nature of controversy involved in this appeal. IA is allowed. Let the appeal be listed for final hearing on 12th December. 12th December. Not 1st December, 12th.
20, yes.
To notice of IA 1 of and 3 record. IA 1, 2 record. Next week, Learned counsel for the applicant prays for a short accommodation to enable him to file an affidavit of assets and liabilities. This on 2 days you say. Come up on 14th November. 14th November. Not interested. Government advocate, you said, Mr. Natras.
Government appeal only.
Not interested in prosecuting the appeal. He has met you privately, your officer. Good.
High Court is there. And
Your name is called
compulsory retirement. Dismissed from service. It's already an interim order, we will admit this.
appeal is admitted for
The
hearing.
delay has to be controlled.
Oh, heard on IA. One of the reason assigned to leave. But when delay IA allowed. Heard on the question of admission admitted. The moment the appeal is admitted, the court should automatically fix a date for hearing, right? The moment appeal is admitted, respondent gets a right to seek a date of his choice for hearing. Is it the law? I never knew as a counsel, and we do not. So ask him, he will suggest what to do if you want the case to be listed. Ask him, or ask him also, you can meet. He will guide you what to do.
Number 24, the MP Telecast.
Oh. Mr. Shrikant's case.
Notice.
Which case you will accept notice? In his appeal.
It has to be issued.
So what WA issued notice?
510. Appeal number 510 notice has to be issued.
Issued notice WA 500. Of course. So, who accepts notice? Behalf of respondents. Is on behalf of. Yes, who appears search committee, you are there. And state of a notice on behalf of respondents is accepted by learned additional government. So dispute is with regard to. In your case, there are only 2 respondents. 4 respondents. 4. All right, 4. Yes. So then search 1, 2, 3, right? No, but this Vice Gulbarga, he will appear 1, 2, 3, right?
The university
Chairman. You appear for respond number 3 also? No.
here.
That's what we are asking. So 1, 2, 3 and 4, Dr. A. Rangaswamy, you appear. So and so learned counsel accepts notice on behalf of respondent number 4. Which should be here. 5th December. List for hearing on 5th December 20. Interim order.
Number 25, CH Sharavana.
I think of the activity, I just want to important inform and was understood by the government. In respect of the entire acquisition notification, issue certificates to all the landowners. This order was brought into learned signature of the law report. Learned signature certified, holding that was the judgment application as the petition to the Supreme Court is concerned. That order is now waiting for the orders of the learned signature. Sorry.
11 appeal, there is an order already on order 22/10/20.
We get all this. 8th November. 11, Monday.
20th now.
All right. Will you prepare a synopsis, Mr. 20, we will hear 28 September, sorry, November. This hearing on 28th November 20. On November, Monday.
I have submitted all notes to normal.
Right. Interim order, if any, shall continue till
but actually there exists more in there.
there is an interim order operating, right?
Preparing that road existing. That is only problem.
Please file,
Don't do what they want.
please file an application. If it's urgent, we will consider. No, let him file an app. Not only. Interim order shall continue. Yes. We will hear you. We will hear you on 28th November. We'll decide.
But 96. We have to estate.
Ah.
If we deny it, we can manage the book.
Why? Tell him there's nothing. Read para 10. What senior advocate will do? Okay, keep it pending for another 10 years. We'll adjourn it by 10 years. What is the use? Read para 10. There is a limit to pursuing things. No. We would have appreciated if you have said that there's nothing in my case. It may be dismissed without recording my concession. We would have appreciated. But this is all old tactics, engaging a senior advocate. Supposing if we may ask you why you are engaging a senior advocate when the case is listed for hearing, and no senior advocate should accept a brief on the day when the case is listed for hearing so as to cause an adjournment. This is against the ethics. If you are not senior advocate, you should know it. And I don't think any senior advocate in Bangalore will accept your brief and allow the case to be adjourned on the ground that he is being engaged. Nobody does it. I have been a senior advocate. We have followed certain ethics. I have been myself a designated senior advocate for my elevation. Read para 10. But you won't read para 10. Fine. Unfortunately, we have to pass an order, Mr. We will, for your satisfaction, read para 11.
I'll read para 10 of the order.
So, how para 11? So you will not tell us, right? We have to read it ourselves. Fine.
Para 10
You will only tell us para 10, then page 65, then 73. Huh? We have to read it.
And we order from the
No, so after withdrawing a petition unconditionally, you can file another petition. This is the law. We want to understand case law. Any provision.
page number 11. Page number 11.
Yes.
I don't know.
It's different. Something called constructive res judicata. So these reliefs which you are seeking, so you have to tell us you could not have sought in the earlier petition.
All is the issue that some few points. All those
Please. But para 18. No.
Please, my lord, may I please explain, my lord, I'll settle that, and this was argued, my lord, I have, I'll convince on all these.
Why not? It's listed for admission. Convince who is preventing you. We are hearing with all attention. No impediment. Who have the fight? Who are the counsel? No impediment. We are hearing. Argue. We are ready to hear. Argue means you don't have any option, Mr. You cannot tell us that I will oblige the court by arguing. You are not obliging us. No, you don't get an impression that I will argue tomorrow means you are obliging the court. Don't, I mean, we will pass an order, capable of passing an order today, sir. Recording all this. And with a cost of 1 lakh. Yes. So it's a case worth imposing cost here. Oh, we will all record this. You are telling all this to us. That I will argue. That senior, you opening sentence, senior advocate. When we told you, read para 10, you said para 11. Of course, we will record in our order sheet. And for filing a frivolous appeal, 1 lakh cost. It's a public time, it's not our time. It belongs to this court functions. And this thing, it's a public this thing. This all frivolous. Cost of 1 lakh.
I'll argue.
No, we don't want to, we are not Canara Bank, right? So we are not getting anything. We don't only want to, no heavy matter. Simple thing is, you have filed a writ petition and you have withdrawn it unconditionally, and thereafter you have filed another petition. The only legal principle is whether you can be permitted to do so in law. This we expect. Any law graduate should be able to tell us. No heavy matter, nothing. All this is this thing. The court has recorded paragraph 10. That's why we asked you that why senior counsel quantum of, after arguing on the quantum of cost, why he withdrew. Same thing will happen this round tomorrow. tomorrow. Prays for adjournment. However, this court was not inclined to accede to the prayer of adjournment. However, by way of indulgence, hearing is deferred to list on 8th of November 2022. It is made clear that no adjournment on any ground shall be granted. You are free not to come. Right? Frivolous. No element of fairness from the members of the bar. We are really startled. Firstly, the appeal should not have been filed. And despite we are telling, this the least we expect that if there is a decision against you, Mr. Counsel, I've been a senior counsel. If there is a decision against me by the Supreme Court, I was the first one to tell that, sir, this is the case against, don't record my concession. That's why probably I am here. Unfortunate, mister. Your client has not purchased you. You're not his servant. You are an officer of the court. Unfortunate. Simple thing. You are telling us heavy matter. What matter? How heavy it is, we will tell you tomorrow. We will extremely make you light with costs. Fine.
27 average, yeah.
Yes. Nothing. All this is what arguing counsel. We should have declared Monday a holiday. You should have told these people, no, that we are seeking adjournment in all cases. Nothing. Argue. Huh?
34 years.
34 years delay, you know it. What? Thank you. Challenge it in Supreme Court. Yes, madam. It's in no, nothing. No password. This always, Mr. We are bound by our judgments. Number of judgments we have delivered. You should have told us in fairness that there is 34 years delay in filing the application for resumption. Nothing can be done. We cannot take a contrary view. Merely because you are appearing, our judgments bind us. We have been dealing with these cases day in and day out. There is no question of it being passed over or arriving at a different conclusion. Understand? And you know it very well. The bar knows it by now. That's why they keep the appeals in default and keep it pending. You know how many years of delay? Huh? 6 months?
He's in profession for this.
Not profession. Delay in filing the application for resumption. Oh, don't appear here. It's a wrong court to appear. Don't proxy counsels we don't welcome. Don't appear. If you don't want us to record your presence, we will not record the presence. No proxy counsel, nothing. Don't appear. There's no Advocates Act. It's not, proxy counsel is not recognized, right? How many category of advocates? Advocates and senior advocates. Section 16 of Advocates Act. You read it, if there is anything, proxy counsel, standing counsel, sitting counsel, running counsel, is there anything mentioned? How can you be proxy counsel? Nothing. You take the responsibility of the result of this case by appearing in this. Don't appear, don't oblige anyone by appearing just because you are 6 months into the profession. But that will spoil your reputation in our eyes. We will think that he is a non-serious person, doesn't know anything about the case, and you will be spoiling your future. Point. Come only when you are prepared. Otherwise, don't come. No proxy. 34 years, right? This intra-court appeal arises out of an order dated 26th November 2021 passed by learned single judge, by which the writ petition referred by the appellant has been dismissed. Paragraph facts giving rise to filing of this appeal. It stated that grandfather of appellant number 1 was granted land measuring 4 acres of survey number 130, old number 1, situated Bani Mangala village, right, on Bangalore, Devon Street, page 80, para 2. Full stop. Subsequently, was granted in the year 1955. Full stop. So, Sagu Wali check was issued by the Tehsildar on 7/1/1955, which incorporated a condition that the land should not be alienated for a period of 15 years. However, the land was alienated. However, land measuring 2 acres and 20 guntas was alienated by a registered sale deed dated 6/7/1971. Full stop.
8969, first sale.
8969
And subsequently,
and subsequently by a sale deed dated 6/7/1971. Full stop.
2000 per application.
Thereafter, when date you forgot? 13.
2000 per is one.
Thereafter, in the year 2013, an application seeking resumption was filed. The Assistant Commissioner by an order dated EC allowed the application.
Deputy Commissioner set aside.
The Deputy Commissioner by an order dated 23/11/2017. No, 21/2/2019. Sir, Assistant Commissioner is 23/11/2017. And the aforesaid order was set aside in appeal by the Deputy Commissioner by an order dated 21st February 2019. Full stop. Paragraph.
Confirmed in the expedition.
Paragraph. The aforesaid order was assailed by the appellants in a writ petition, learned single judge by an order dated so and so. 26th November 2021 has dismissed the appeal in the aforesaid factual background. This intra-court appeal arises. We have heard learned counsel. There is record that paragraph. Admittedly, land was granted in the year 1955 and the same was alienated in the year 1969 and 71 after a delay of 30. After a delay of 34 years from the enactment of the so and so act, the application seeking resumption of the land was filed. The aforesaid was filed. The filed for which no plausible explanation has been offered in view of aforesaid when whatever. Not find this.
Number 28. The Sampakaram pending.
Delay is controlled by of 5 days in file. Yes.
I could have raised this. The decree number 1993 of. In fact, I had no offer. How far as section 24(2) of the Act is Act 20 of 2013 is concerned. It is a right accrued to me. I know this aspect of the matter has not been regulated in any of the previous decrees. And this your lordship was pleased to.
Yes.
In that,
You should go before. We are not saying that it's correct order. Test it before Supreme Court. I mean, it's wrong. Supposing if we tell you why we are forget about this review, we will hear you. Supposing if I tell you you are wrong, what's the first reaction? You say no, no, sir, no. Will you admit your mistake if I tell you? No.
yeah.
Oh, you argue. All right. It's like telling the judge, you challenge it in Supreme Court. Oh, challenge. We whatever missing was that perhaps we were liberal to you by not imposing cost. That's the mistake which is apparent on the face of the record. To that extent we agree that we should have imposed a cost of 50,000. On
Challenge.
Challenge it.
On the ground that I could have challenged it. In the value itself. That order makes it clear that we did not have an opportunity to educate the right which agreed to be by Act 30 of 2015. To that extent, I request this honorable court.
Yes.
My honorable, none of the restrictions brought this point was constructed rectification that should have been the same point ought to have been educated.
No, we understand. Like you can challenge, like we will tell you how you can make multiple changes. Like the land is you challenge the preliminary notification, then file another notification. We are telling you just not the, like you challenge preliminary notification on XYZ ground dismissed. Then challenge final notification saying that at that time when my earlier petition was filed, final notification was not there. So I will challenge it. Then thereafter, then section 25, 5 years have passed, the scheme has not lapsed. That ground was not available in previous two litigation. So I will file after 5 years. Thereafter, then that was not accrued to me. Then that possession is not taken. Memorandum. So court petition. So all these grounds are not available when other petitions. Yes, sir.
Well, I'm telling you, so this repeated with the state government. This land acquisition officer, the intent here, the beneficiary.
Oh, yeah.
This is admitted, even state government on the facts should be clear. It is on the urban land. Agreement with the state government. And here, the contesting respondent number 3, without there being any iota of material possession. The current response they will come in. And they have filed a civil suit. But all these facts are the appeal memo are in 3 volumes.
Okay. Okay. Yes. Yes.
There were suits filed by the third respondent seeking possession. All these facts are current. Now, let's say they used to discuss on only on 2 ground, on the ground that notification under the media. That is to that extent the legislatively underlined. Second, as a constructive restriction. Constructive restriction is from not taking possession. And even in the earlier round of litigation, none of these is. That's why I would instead of the neurological also.
Yes.
What's the restriction?
This is not, this is something synopsis you are trying to give written submissions, right? To make a ground for SLP. Huh? Make a ground for SLP that I had given before the High Court. No, you take it. We are not asking you to give synopsis. No, this is not fair. You argue, we will note it down. Whatever point, yes. What is it? So that 2013 Act, the issue with regard to applicability could not have been agitated in earlier round of litigation. Not have been. Has not been, constructive res judicata will apply. Could not have been agitated, that's permissible. Not have been agitated in earlier round of litigation.
It's not dual. It's Preventive number 1993 of 2013. Disposed on 15/6/2016 was admittedly after the act came into
93.
15/6/2016. I don't also was pleased to observe that I could have heard this section 24(2) of the act in that because it was disposed on 15/6/2016. That will also be kindly see. There is an order of division at page 60, which was on 15/6/2016. I have taken because there was a dispute with respect to my identity. And thereafter I went to the civil court, identified myself and filed this.
So this finding that it was open to be agitated in WA number so and so is wrong, according to you. Para 4, we have said that you could have, it was open to be agitated in WA. You say that is wrong finding.
I have no option. Your Lordship of please rely upon this.
So
Yes.
exactly this is what is saying. We are saying this finding is incorrect. You read para 4 of our order. Last line we have said that this ground was open for you to be agitated in WA. According to you, that is incorrect because you could not have agitated that ground.
Yes, because this was
Got
not, I had no opportunity to participate in it. To that extent, my respective opportunity to that.
Yes,
It's an error.
of course, an error. Everything. The moment you succeed, it's correct. The moment you lose, it's all error. Everything wrong.
This is
So who has made them judges and all that? No, yes.
the other judge single to say that because it is under the media, that cannot be done. To that extent, there is an error.
There's no error here. We have not said anything about PDA.
Except all of the other single judge.
So on different grounds, it can be accepted. Even supposing if on 5 grounds an order is passed and we accept it on 1 ground, then we need not go into other grounds. We have not examined.
Regarding constructive certificate order. The constructive certificate was taken into account because I could have raised this in the recap. That is 15/6/2016 after the act came into force.
Thanks, sir.
Valid or. And if error cannot be pointed out in a review.
Even state government. Immediately, it was with the state government. Under the land, urban lands in India. In the recap.
Petition should be allowed with cost. Rate appeal. Rate appeal should be allowed with cost of ₹2 lakhs. Hear us means we did not hear you.
Only part. But because the state government's position is very, very important.
Perhaps it is not your ground in review that you were not heard. It's the ground that you were not heard before an order.
You cannot be appealing debts. I can't. All that and the threshold it has been discussed. Taken. Yeah, urban side, you also I have stated not page 39. Yeah, 39. Even otherwise, having it of the land the state in terms of the political for the urban land area.
Said that
But
was-
not the center for being available.
it's not said that he's not heard. We have heard him. We have heard. Yes, yes.
In the light of section 2. These are incident facts which I feel, no, now the applications are banned. You consider that. I request this one.
Stay.
Okay,
Stay also. You are seeking, right? Stay you are.
Therefore, you the clear was in that the light of section 24 2.
Yes, sir.
further submitted.
Yes, sir.
That's it. Anything else? Anything else? Thanks. Thanks. Pass them.
But 29.
Admitted for hearing notice record.
30. Senior KDS.
Admitted for hearing.
Number 31. The GD.
Admitted for hearing notice record. Heard
Yes.
on IA. It's 2022. After hearing learned counsel for the applicant, it is directed that operation in effect of impugned judgment and decree so far pertains to dissolution of marriage shall remain state till next state of
32. The GS Balgangagar.
admit notice record.
Number 33.
It is state
Only with regard to alimony.
dismissed with cause. Password. What password? Admitted for hearing. Issue notice record.
34.
Admitted for hearing, issue notice record. 1 minute. One. Yes. Mr. So and so Shetty. Learned counsel. This is review petition 28. Heard on
Is well known in filing ever. But any case without filing a review.
probably way forward, right? So, I review, yes, or dismissed. All right. This petition has been filed seeking, we did not impose last, right? We should have. This petition has been filed seeking review of the judgment dated 29 September 2022, passed by this court in WA number 426 part 2020. We have heard learned counsel for the applicant at length after hearing, we are length will stop in our considered opinion. The judgment dated so and so passed in neither suffers from any error apparent on the face of the record, nor any jurisdictional infirmity, interference of this court in exercise of review jurisdiction. The result, review petition being bereft of merits is hereby dismissed.
Particular matter. Number 14. The debit B.
Habeas corpus.
Yes. Where were you? Or when will you argue? Then it's on HPP. Receipt ready to argue. Where is the SPP? You argue tomorrow or day after. Ask him to be a day after.
Right.
Not day after. 9. Current counsel corresponded case for short accommodation. List on 9th November 2020. Current counsel for the petitioner submits that he has received the copy of statement of objections. The office objection is therefore ignored. List on 9th November 2020.
The final hearing. Number 35. And the last day, the respondent stage again. Valat is done. Land is done. Those are things, Valat is. Setting of the pay at the time of there. The second point.
And coming to this one, report of 14 years says that the association of authorities have engaged themselves, it is within their knowledge, they have they can be now saying at this point of time, I want to indicate that I think now this is therefore go up. Inconvenience feeling until
right now the allotment. These are the check and about 150 acres of land. The first matter where the order of stay has been granted.
12 years have passed. How long we should keep it pending? 2010 matters. The youngsters are sitting here. They are watching you and us. That if we adjourn, all other cases will be adjourned.
You were ready in this matter several times, but there was no time.
This will be the last time. We assure you. If you argue, this will be the last time we will argue. Because several times means it's not the court where you are required to argue a matter several times. You know it. If you don't know, ask Mr. Naik. We will decide it. We will decide it the moment the arguments are heard. You will not be required to argue several times. That's the assurance. Why do you file Mr. Naik such documents?
if I allow them to argue, then pointing out in my relation, it is
So we will ignore your documents so that ground of adjournment disappears. Let them argue whatever.
Even on the last day, when it is to start for the date, today is the date you are. Today, yesterday, when it is to work to me, today that is usually because you is not in state. So let it be on the Wednesday, near it. Very good.
The Red Council for the
Last day will take first day, it's the last. Friday is a holiday.
appellant prays for adjournment. The appeal is of the year 2010. However, reluctantly, the hearing is deferred to 9th of November 2022. It is made clear that no adjournment on any ground shall be granted. No, we don't. We don't know. The moment we say a date, you are bound to oppose it, right?
It's not about
That's what it is.
You only said Wednesday.
No council has ever agreed to the date given by this thing. Always say, if we say 9th, you will say, if we would have said 10th, you would have said 14th. 10th of November. 10th November. No adjournment.
you are ready. In fact, earlier I can-
We don't know. You are seeking an adjournment. We have, Mr. Gracefully, we have adjourned it. As per your convenience, we have fixed it on 10th of November, only with the condition that no further adjournment shall be granted. Please be ready. We are telling you that don't create an embarrassing situation for us on 10th by seeking an adjournment. We will not grant adjournment. Because of your seniority, we are accommodating. Any other young person would have appeared, we would have thrashed him right, left, and center by saying that 12 years case, 12 years the case is pending, you are seeking. We have adjourned it 10th November. Please do not seek and we will not grant adjournment. Whatever it is.
Yes, sir. It is decent to us.
We don't know who was appearing. We are talking about 10th November. 10th November, it will not, we will not be adjourned. It will not be adjourned. Yes. Next.
Number 36. CK Arida. CK Kumar Patil.
Ah, yes. Yes. Oh, after a long time, Mr. Krishnamurti. Sorry. Ah. Ah, yes. We learned about it. When do you want? Same condition. Choose the date, same condition, no further, whatever. Date you tell us jointly. Yes, Mr. 22nd November. Huh? No, fine. Jointly pray for adjournment list on 22nd November 2022. Make clear that no further adjournment. On any ground.
37.
Only thing. Very, very difficult for them. And they have to take care of. Yes. This is.
Before we unique right short review.
There are fruits he has not come before us.
You were there.
Yes.
Not pronounced statement.
Yes.
But I
After
know.
that he did not come.
37. Please appeal.
Last.
37. Sri Anand Kumar. Pass over. 38. Parthasarthi. Government Advocate. 39. Sri K. Kittegoda. Sapahat Sultana.
What happened? Petition is dismissed, right? I mean, penalty has been appealed. Ah. Got it. Who are you? No, not PD. Which employee of a bank, right? What did you do? Sanctioned loans inadvertently. So then what are the charges? Ah.
One borrower whom the notice was. What is subsequently moved in respect to the same borrower account. The borrower was very much available and it was not a case of non-servicing notice was not a case of non-existence. And because the second aspect is then the entire of the cable. That what he does is he extracts what is the defense or the defense he does not consider it. What he says is in one sentence, he says evidence of MW1 substantially answers. That is the way, that is the type of consideration I agree what they had. Then I file on the service of inquiry of report on me. And when I am called upon.
So it's a case of or remand, right?
It is a case of remand for unreasoned order of the report.
And speaking order.
Unreasoned order of the.
Appellate authority.
Connection. The. Page 95 is the report there.
Right.
At page 97, last paragraph. The defendant has argued that the clarification of the content of the the guarantee for the representative of that. If we are present at the time of confusion, property is also carries the full of the business. Available. Then now here we go beyond it. I come to the evidence. What on the argument you can hear. The evidence of the political aspect of you. Here, trace to this in the present design of any of the 3 4 years fact the bank has not been legal in all this proposition letters are going to be printed. This is all without any evidence and without reference to any evidence. And last sentence. The consideration of my defense is only in the last 4 lines. The depositions of MW1 and MW2 is sufficiently answers the contentions of except mortgage of third party was obtained, except the charge of obtaining mortgage of third party property, all other issues level regulations.
Where is the order of the disciplinary authority?
Order of the is the page 118. The order of rejecting the annual findings is page 120. There is no reference even to the objections I wrote against the except once by page 120. The chartered officers are made submissions made like this. That is dated also which has been duly taken into consideration. As a result of the records and submissions
I absolutely
Oh,
follow.
where are you reading?
That page 120.
120. Which part?
The last.
On perusal of records.
Above that.
Upon.
Uh,
How old?
This is wrong now. As enumerated, it is only partly true. Which was forwarded to this group for his submission. The county council has made submissions by a letter dated date, which has been duly taken into consideration. And then now the records. Down this one. And page 122, last two correct. Does the record reveal that Kanini Playa has not accepted his due diligence, which has resulted in payment to loss of the bank? Hence, it is replaced by the submitted by the PS. Therefore, not held. Can we have a look at my reply? My reply is actually annexation E page 109, where I make specific reference to the PR 920 regarding the appraisal of the credit proposals. And I also say that every one of the token is they are part of the credit appraisal report, and it has been informed to the controlling office. But I am not yes, discussion to reject. All that I am maintaining that is this is my submission. It will not accept. Yes, that is what I.
Yes. And appellate authority order. Page.
Is that 155. My appeal is that page 156. Appellate order is that page
155.
155. The order executed page 157. Page 158 of this is agreement by the individual labor incident. Here, I will say it has been duly taken into consideration. Then they like there is no specific contribution to this function.
That's it. Yes, madam. What are you reading?
Important on the and this is the very of that is more for people in the name of the very great love. And that's not what next get by listening
No, he has not argued that not of no opportunity. Non-consideration of the defense. So therefore, there is no question of opportunity be granted. That's not his grievance.
I did. So think of the inquiry, you know, see that I also concentrated on this stuff, cannot die. If we get to also completely. Consider.
Yes, that's all. Anything else? Synopsis you have given. What where have ah,
My argument was there is no reason. And yes, such reasons are there. And in the interpret that para 22, I raised a specific one. The order of the first round is there is page 22. It is not the inquiry as the all followers and formality not being given to the formality. And again, college authority not assigned this is specific round right at para 4 round 4.
read appeal.
Page 24. The order of the appellate is the second part of kind of book. The order of the body electronic management is going to deal with any of the content of the appellate. contrary statute regulation. Relation 17 is identical like CCA. With the finding of then now self-conviction in respect of the disciplinary authority in page 22. Towards the end of the road work. And third party guarantee. Third party. There is an aspect on which I have been examined.
Jay Kumar के
Settlement.
Oh. This intra-court appeal, no, not this MFA. This appeal under section 28 within bracket 1 of the Hindu Trial Act 1955 has been filed against judgment dated 3rd September 2013, passed in NC number 18 of 11, by which petition filed by the respondent under section 13(1)(1)(a) and 1(b) of the Hindu Marriage Act has been allowed, and the marriage between the parties has been dissolved by a decree of divorce. Paragraph. When it comes for the parties along with their counsels present in the opening district. During the pendency of the appeal, the parties have amicably resolved the differences between themselves and have filed a compromise petition under Order 23, Rule 3 of the Code of Law. 3 to 10. The terms and conditions of the compromise arrived at between the parties read as under para 3 to 10. You of aforesaid compromise arrived at between the parties, judgment and decree dated so and so, passed in MC number so and so is modified accordingly, and the appeal is disposed of in terms of the compromise arrived at between the parties. With their signature.
Confirm it is modified in terms of this, that's it.
everyone.
Management.
single case may not, government may not, 11 years proceedings or given global. Even not one.
Why it has been allowed?
On the ground that 11 years notification issue, section 4(1) Red Book 17 of the urgency class by the government.
What urgency clause invoked, so what? It's bad.
Position in respect of 3 acres 3 room class is concerned. The same was that.
Why it has been allowed, mister? We asked you why it has been allowed. Or we will read it. Wait.
What was possible beyond the period? What is the people?
Why page? Tell us why it has been allowed.
On the ground, my lord. Our senior contemplation section 11A, and there is a delay in the order.
11A, there is no procedure. 11A only says that from date of declaration under section 6, award has to be passed within 2 years. That's the only thing.
Has been considered by the Supreme Court very recently.
So 11 said what we are trying to, you are saying procedure under 11A. 11A does not provide any procedure. 11A only says that within 2 years award should be passed.
On the ground, my lord, last of the time, so that is the ground which under single bid as a study. Last of the time, page 35, included page 21 of the I.
Right, it's an act. Yes. Good. Great. Good mark. It was heard before which bench? This case.
Yes.
Both are in dispute, 3.03 and 7 acres.
Yeah.
Huh?
Let's only 3 acres, 3 acres. So far, 7 acres, you have not taken possession of the lot.
You have not taken possession.
Yes, 3 acres, 3 acres, the lot is located.
Then what is your answer to this 11A?
Then you will not, that is how to clarify. It is-
No. So let us be clear on dates first. Before going to 9/12/2004 notification under 4.1,
Yes.
and then notification under section 6 was 16/2/2006,
Yes.
right? And award is on 21/6/2008. Right? So it is beyond a period of 2 years. What is the effect of 11A? What Supreme Court says? Not mandatory, cannot be quashed.
Dependency clause was issued, and the parties are my lord.
No, so what does Supreme Court say? Yes. Emergency clause means, so urgency clause means 17.1 means time limit of 2 years does not apply. It should be only urgent, right?
Final notification is issued after 1 year. If there is an urgency clause, then why delay anything final notification? After 1 year.
This time. You get it right. This time. So what day? We have read it.
Right to go. The right to the condition of following, right? The requirement of standard payment of 80% of the estimated compensation as contemplated in section 3 or section 17 of the. The requirement to pass award within time frame contemplated in section 11 of the notified in section 18 Act. Can the process be considered as a decision made on racial distance? Not the. Anyway. The outside, unless you make something for the respondent, the attempt to change the existing previous page. Attended with regard to
Then why should you read submissions of counsel? That's not the law.
Operating. That's my case.
26 is yeah.
Apart from the reasoning,
26 is yeah.
26. Which shall be applicable cases.
Not complied with. Then it's applicable.
that's right.
Para 26.
That. The thing is happening. Requirement is compliant, person is data, after sentence paying 80% of use, there is a need to pass on. And pay balance compensation within a regular time. Figure of section 11A, fact,
So when did you deposit 80% of the amount of property?
One. Not deposited in the.
When?
They are paid, but it seems. But.
So 80% of the amount of compensation was deposited before November 2006. 9/11/2006, they have taken possession. Before that, we need to find out, right? Your statement is not sufficient. Otherwise, it would have been so easy. You say that petition, no, you say that appeal should be allowed, therefore allowed. It's not, we can't do like this. We are trying to ask him. He has been, you said, my friend has a record. We are asking him, friend has a record or not. Then you have the record, right? Where to find out? Tell us. Hey, madam, help him. Find out.
It's not his time. We have pointed him earlier also. He does not know. Look into the records.
That's why. Madam, you please find out and tell. He won't be able to find it out. You know. What are your instructions, Mr. 80% of the amount of compensation was paid or not paid? They paid or not paid? Then the
Not given for removing this. Somebody also always. They could be referred to the other stuff. Ultimately, it's part of the- it's not equal. Consider as
also justification of, there was no justification for invoking 70. And other ground is 11A. So if they have not deposited, gone, 11A lapses. We can't do anything. What compromise? What the other bench had asked you to, what compromise? Not inclined means? What not inclined? He said 7 acres is not in dispute. Only. Who made the? No, so the dispute is only with regard to 3.3 acre and 3 guntas, right? So what they so their 3.3 acres, they have they utilized the land or whatever. So what happened? What have they done? Solid waste management. That's all. No, no STP plant.
2006. 2016, the handed over. They are investing in the is not garbage collection and disposal of garbage.
Solid waste management. What like dumping ground, solid waste management. Their own innovative way of a local body dealing with making somebody's property a dumping ground and saying it's solid waste management. You have not installed any machinery, etc. Right? There is no plan. Dumping garbage. Yes, madam. The
Deposit of
proceeding
80%.
proceeding itself leading to order sheet of the land acquisition officer, will find it that 4-1 issued along with 17-1, then 80% of the amount of compensation deposited. It must have been recorded in the order sheet. If it's not there, gone, then what can we do? In any case, it's an open ground encircled by a boundary wall. So,
2006 onward.
is it?
Yes, like.
Realize that doesn't mean that you can do anything. We are bound by law, right? You have cited it. Right? If you have not paid, what is the cause this thing? If you have not tendered 80% of the amount of compensation, you know information. You will go there and see, mister. It's otherwise your acquisition. You go there and help, madam. You find out. So you yourself are telling us if you have not, they have not tendered, gone. Acquisition goes. We can't help it. Let him sit, Mr. Comment Advocate. Let the counsel for petitioner sit and watch. Inspect the record. You sit down, be comfortable. We are not asking you to stand. That's it. We'll find out. It must be mentioned in the order sheet of the proceeding before the land acquisition.
There was a deposit, it should have found place in the award.
Award also it must be mentioned. Please see. Because they have seen how much amount payable.
That is after issuing final notification. That is not a complaint. It's an award. That is not complaint.
There were two acquisition Seven acres.
Same year.
Seven was, seven or eight because it 7 acres.
But both,
It's quite both.
yes, but both. 7, they have said they don't want. They only want that 3 acres.
Executed something of
That is only 3 acres.
the. I thought
Actually, they had filed an application.
No, one thing we want to know from you, there were 2 separate notifications, right? One is in respect of 3.03, 3 acres, 3 guntas, another was 7 acres, 7 guntas. So what happened to 7 acres? I don't know. Both have been quashed by single judge. Second one, why it is quashed? 13 ones. You don't want 7 acres, right? Huh? Don't want 7 acres. So government in that case will have to issue an exercise powers under 48 to do de-notify the land, right, sir?
It's already passed.
No good justification to invoke a basic law.
Mm.
What will be the 6th beginning?
After 1 year's final notification has.
All right, yes. So did you find out?
One more time.
Why? The record is here. Record is here and you, that's why we ask you to go there and inspect. You have seen, there's no deposit. We'll say that you have also inspected the record, unable to point out that it has. No, inspect it right away. We are waiting. Inspect it. Madam, the question is of the tender of before they have taken possession on 9/11/2006. We know it must not have been done. I haven't come across a case where so far in my career where they have deposited because they don't know the law. They would have taken possession. So, madam, see 9/11, it has to be deposited before 9/11/2006 because 9/11/2006 is the date when they have taken possession. You should also, it's not that you have been absorbed, right? We are trying to help ourselves. That doesn't mean that you should sit relaxed manner. We don't go there, Mr. Watch, please. I will inspect the record. We told you. It will have an impact on your case. We don't, we will say that it could not be pointed out that amount. It is for them to accept 3 lakhs. He told us that his client has declined. Mr. Rajgopal must have told that don't accept 3 lakhs. You have an excellent case. So law is in your favor. Why will accept 3 lakhs? Fine. No, this is all wrong, Mr. And if we will impose cost if this, they have not sought quashment of this thing and this the ground.
No,
That
no,
they
no.
did not quash
No,
the
no, no,
relief
no,
of
no, no,
this thing, quashment of
no, no.
notification.
No,
And despite that, single
No,
judge
sir.
has quashed.
no, sir. He said judgment was not agreed. Because they want compensation under 230.
No, whatever. It's not, they are not agreeing.
I'm not agreeing. Because
We can't
compensation-
compel them to agree. No breathing time. No, breathing time was given on 19/10/2022 when we said, despite several opportunities for past about 1 year, no adjournment shall be granted on. See, see the record. We are not preventing you. The third time we are telling you. Inspect the record. Third time. Show it to him, madam. Show it to him. Let him find out.
It's 30% provided they receive compensation under 239.
You asking.
Settlement failed because their respondents are insisting for settlement under 239. They should have paid if they have used it and if they want, then they will. Otherwise, they can look for some other government land.
Hmm.
Otherwise, they let them look for some government. Yes, yes.
Sorry.
The photographs are there, nothing. Nothing.
That's how, Mr. You should argue. The way you are arguing, that's how you should argue in each case, less than 5 minutes. Tell us that he has quashed it on 2 grounds and this is what is the, that's it. There's nothing to argue in this case, practically. Where is the judgment? Guideline? Where is that? Which judgment, Mr. Guidelines?
Single judge.
Paragraph. Only one is enough, Mr. Why should you cite so many? Which para? Hey, 1 minute. Which para? 2014. And where it has been followed subsequently. Two 2014 6 564.
That is the latest.
Latest. It must have been followed somewhere, Mr. You have to tell us. Who will tell? We can't search. We don't have time. You have to tell us. 165. 72. No, but where it subsequently, Mr. 2014, 8 years. 2014. Okay, Mr. Nataraj, tell library people find out where it is followed. They have a system, library 2014 6 564, where it has been followed subsequently, and ask them to give a printer. Yes.
In all the matters. In what cases why it is not being protected by the attacks from government party. That means I lost it to administrative.
They needed dumping ground urgently, that's why. And despite that, they waited for 6 months to take possession. Whether deposited or the matter. Write down facts. It's in front of the people. It's an exception to order dated 5th of December 2013. Asking WP number 5417-5420/2009 and WP number 17517/2009. By which writ petition preferred by respondents. Seeking to assail the proceeding under the Land Acquisition Act 1994. Herein after referred to as the Act has been allowed. Writ petitions have been allowed. Paragraph. Facts. Giving rise to filing of these appeals. This appeal briefly stated up that respondents are the legal representatives and the owners of land bearing survey number 64, Kota Gere, Kasba, measuring 17 acres and 10 guntas. Full stop. Facts giving the filing of this petition briefly stated are that land bearing survey number 64 on all that Kota Gere, Kasba, etc. Kasba, Matu, Giri. District in Tumkur district, so and so there is Tumkur district was an Nam land.
There is a payment under section 3A has to be reflected in the award. And 3B says that. The award, Madam, in the award, is there any mention about the deposit under section 17(3)(a)? The award.
Land bearing situated.
He's saying
Tumkur was an Enam land and was governed by the provisions of Religious and Charitable Enams Abolition Act 1955. Of the father of respondent was said to be a permanent tenant in respect of aforesaid lands, was granted occupancy rights in respect of land measuring 17 acres and 10 guntas of Kota Gere. This is survey number 64. You say here in after scheduled land of the scheduled land. Paragraph. scheduled land. The appellant is a local body constituted under the provisions of what act? Panchayat. Appellant is a town panchayat constituted under the provisions of local bodies Karnataka, something Municipalities Act,
Municipalities Act, 64.
Karnataka Municipalities Act 1964. The the panchayat was in 1960. The panchayat was in need of land. Scheduled land for the purposes of solid waste management at Portagiri town. Full stop. Thereupon, the proceeding under the Land Acquisition Act, proceeding under the Act, were set in motion and full stop. A notification under section 4 within bracket 1, read with section invoking the urgency clause, urgency provision under section 17 within bracket 1 of the Act was issued on 9/12/2004, by which land measuring 3.03 acres were notified for acquisition. Paragraph. The aforesaid notification was published in the Gazette on 30/12/2004, and the same was published, whereas the same was published in the newspaper on 17/12/2004. Full stop. After a period of even though the urgency clause under section 17, clause under section 17 within bracket 1 of the Act was invoked urgency clause within 1 minute, madam. 17 urgency clause under 1 of the Act was invoked, comma, after a period of 1 year, after a period of 14 months, a final notification under section 6 of the Act was issued on 16/12/2006. 16/2/2006. Full stop. Thereafter, the thereafter, the possession of the land in question, possession of the scheduled land was taken on 9/11/2006, and an award was passed in respect of the scheduled land on 21/6/2008. Full stop. Paragraph. Similarly, in respect of land measuring 7 paragraph. In respect of land measuring, similarly, in respect of land land measuring 7 acres of survey number 64 was also required by the appellant panchayat, appellant, don't say panchayat, appellant for solid waste management at Portagiri town. Full stop. Therefore, a preliminary notification was under section 4.1 read with section 17 of the Act was issued on 1/10/2005. Thereafter, a notification under section 6 within bracket 1 of the Act was issued on thereafter, after a period of 9 months, notification under section 6 within bracket 1 of the Act was issued on 14/7/2006, and an award was passed on 14/11/2006. Full stop. Paragraph. The validity of the aforesaid notifications The validity of the aforesaid notifications was assailed by the respondents in a writ petition, namely in writ petitions, right? Writ petitions, full stop. The learned single judge, by an order dated 5/12/2013, inter alia, held that in the facts and circumstances of the case, there was no justification for invocation of the provisions of section 17 of the Act. It was further held that since the award has been passed beyond the period of 2 years from the date of publication of declaration under section 6 of the Act, the same has lapsed under section 11, capital A, 11 capital A of the Act, full stop. Accordingly, the proceedings for acquisition of the land initiated by the state government were quashed, full stop. Being in the aforesaid factual background, this appeal has been quite parallel. Were quashed. Learned counsel for the appellant. Learned counsel for the appellant submitted that even though the award has been passed beyond a period of 2 years from the date of declaration under section and publication of declaration under section 6 of the Act. 6 of the
From 6 it is.
11. Mr. 11. Land acquisition. Yes, please. Yeah. Yes. 6. Section 6 of the Act, comma, though award has been passed. Yet the amount 80% of the amount of compensation as required to be which is under 11, which to 80%
17 3 years.
Yet 80% of the amount of compensation as required to be tendered before section 17A3 of the Act.
17 3 years.
17.3A. Capital A, hyphen dash, 3 hyphen dash A, bracket close. A of the Act was tendered before taking possession of the scheduled land, taking possession of the land in lands. Therefore, section 11A, therefore the provisions of section 11A of the Act are not attracted to the fact situation of the case. It is further submitted that since the land was required for an urgent, was required for a public purpose urgently, that is for the purposes of solid waste management at Kotagere town. Therefore, the state government was justified in invoking the provisions of section 70 of the Act, full stop. In support of aforesaid submission, in support of the submission, that provisions of section 78 of the Act are not attractive. Mr. Find out where is it reported. It is
14th October.
Overall in air to the index.
Delhi air.
Yes.
No, not it. 2022.
How can it be?
He's telling this 2014 is over.
14, 6 years.
We are asking you, where is it this reported? 14th October 2020. May not be reported. In support, yes. The submission that provisions of section 11A of the Act, you write down 14 overruled where, Mr. Bhattacharya? Give it. 14A of the Act are not applicable to the fact situation of the case. The reliance has been placed on decision of Supreme Court in decision of Supreme Court rendered in civil honorable Supreme rendered in civil appeal number 24 part 2009 within bracket dated civil appeal number so and so dated disposed of from 24/10/2022.
14.
Oh, sorry, 14/10/2020. Must not be reported. A 2014 judgment has been overruled, Mr. 2014 judgment has been overruled somewhere. We are getting it. He should find out how do you assess, Mr. Citing an overruled judgment is a misconduct, right? Yes, madam. Paragraph. On the other hand, learned senior counsel for owners of the land submitted that owners of the land submitted respondents submitted that learned single judge has rightly has correctly concluded that the action of the state government in invoking the provisions under section 17 of the Act is not justified. Stop. It is further submitted that learned single judge has rightly held that the proceedings of the Land Acquisition Act initiated proceeding for acquisition of the land have lapsed under section 11A of the Act. Paragraph. Learned additional government advocate, right? Additional government. What is it? Now tell us. Huh?
50%. Requirement of section 17(3)A is 80%.
When did you deposit? 13/8. Oh, that. No, that is not. What happens?
It's a
You ask the
proposal.
beneficiary to deposit the cost of acquisition. Madam, that is asking the beneficiary to deposit the cost of acquisition proceeding. The acquisition proceeding itself commenced on 9/12/2004. So therefore, it's asking the beneficiary to this thing meet the expenses for acquisition proceeding. It's like that. So that will not help you. In any case, it's not 80%. Learned additional government advocate on perusal of the record fairly stated that 80% of the amount of compensation has not been Report senior counsel. Senior submissions as in support of a social submissions has placed reliance on decisions of Supreme Court. On the other paragraph, on the other hand, learned additional government advocate on principle of the record clearly stated that 80% of the amount of compensation which is required to be tendered in terms of section hyphen dash capital A bracket close of section 73A of the Act has not been tendered. Paragraph. We have considered, yes, Mr. Para 23. It is not necessary to deposit.
Normal circumstance. In normal circumstance. And labs is and in your legal lab. Another fact. Land belongs to the British. Stand alone.
That citation is reported in which Delhi Air Tech.
Which
Land level.
Utilize online. Yes, online it is.
Hence, reversion of the land does not arise. The courts are registered by Lakshmi Devi. Not registered.
There were many land laws.
The purpose for which the land was acquired was written in Lord Wisdom. The land was already utilized. In the Lord.
have you seen the paragraph annexed with the memo of
Yes. Para 23, larger extent of the land was utilized. That will not apply to your case because there is only single landlord here.
dumping waste there? People here, right, full property, the constitutional right, all that, those judgments. Right, we have considered these submissions made by learned counsel for the applicant and the record. Right, to hold property, so not a fundamental right to the whatever right, it's attached and property. Section 11A as well as 17. 3A. 11A and 17. Yeah. Involved in this appeal market. Acted below 40. Thus, from perusal of section 11A of the Act, it is evident that is declaration and that in case an award is not passed within a period of 2 years from the entire proceeding for acquisition of the land shall lapse. Section 17(3)(a) of the Act provides that before taking possession of the land as provided under subsection 1 of the Act, the collector can tender payment of 80% of the compensation for such land as estimated by him to the person interested in that. The Supreme Court in Delhi Air Tech Service, Honorable Supreme Court, Typically, Airtech Services Private Limited and another. That's judgment of Airtech. Yes. Held as follows. Para 26(1).
Given.
Section. Whatever you have to say, you tell us. Don't like it's a difficult job, right? Writing a judgment, not that easy. If somebody keeps on argue whatever you have to say. We thought that 80% of the amount has not been tendered. 11A as per your judgment only. Three judgment state that it will have. Fine.
Those are the parameters.
Oh, what parameter?
Is in view of para 20. That is in view of para 23, because the major portion of the lands were utilized to come into various other.
1 and
1 and 2.
the relevant extract of operative portion or the judgment bench of Honorable Supreme Court in so and so has held state as under para 26 1 and 2. Like this. Admitted. The record admittedly in the instant case, the collector has not tendered. Liquor has not tendered 80% of the amount of compensation for taking the possession of the land in question. 9/11/2006. Therefore, in view of all laid down by 3-judge bench of on Supreme Court in so and so Delhi Private Limited and the rules of section 11A of the Act apply to the fact situation of the case. The notification has been issued. The notification in respect of acquisition has been issued. Land measuring 3.03 acres has been issued on 9/12/2004. The final notification was issued on 16/2006, and the award was passed beyond the period of 2 years, 2.5 years. That is on 21/6/2008. On 21/6/2008. That is beyond the period of 2 years. That is 2 years and 4 months. Therefore, the learned single judge has rightly concluded that the proceeding in respect of land measuring 3.3 acres of survey number 64 situated at so and so oblique district so and so have lapsed under section 11A of the Act paragraph. So far as the paragraph, as far as the dispute pertaining to 7 acres of the land of 64 is concerned, former learned counsel for appellate as the learned counsel for the appellant has stated that the appellant does not require the aforesaid land in question. Does not require the aforesaid land in question. But I have lapsed. That's thereafter you add lapsed. What is the from the perusal of the photographs annexed with the memo of appeal, we find that the appellant has only constructed a boundary wall around the land measuring 3.03 acres and is dumping waste on it. Therefore, waste on it should come somewhere. Here. I take a proceeding have lapsed. I don't know. Overruled. Overruled. Not developed. Not developed. But this is tender and this is deposit. This is not an authority. For example, at that point, it has not been overruled. Which is the leading judgment, Mr. Rajgopal? Guidelines on section this thing 17. Which is the one you tell any one of that, not all. One judgment. 27. What is it? Guidelines you said, no? Which one, Radhesham? Which paragraph? Huh? T24. T24. But is nothing to do. 2024. Which page? Hey, which page? And where is it followed, Mr. Raj? See, where is this followed? 2011 5 SCC 5. Three, four. Repeat that sentence. Paragraph, next paragraph, fresh. Delete this. We'll record it later. Paragraph. Honorable Supreme Court in Radhesham, RADHY, Shyam, and others versus State of Uttar Pradesh and others 2011 5 SCC 553 has dealt with the scope and ambit the exercise of powers under section 17 of the Act and in para 77 has recorded the following principles, has culled out the following principles. Page yes. In the instant case, comma, the rights of respondents, right of the respondent to a fair hearing, right of respondent to a hearing and a hearing in an inquiry under section 5 capital A of the Act has been taken away without any justifiable cause. No, delete that. In the instant case, comma, notification under section read with section 17(1) of the Act was issued on 9/12/2004. The full stop. If there was if there was really an urgency in acquisition of the land, the appellant ought to have acted with quite promptitude. However, the possession of the however, the final notification was issued after a period of 14 months. However, final notification under section 6 of the act was issued after a period of 14 months on 16/2/2006, and thereafter nearly after a period of approximately 9 months, the possession of the land in question was taken. Full stop. Therefore, it is evident that there was no urgency in acquisition of the land in question, and the appellant and the state government was not justified in invoking the uh, urgency provision as contained in section 17 within bracket 1 of the act. Paragraph. What sentence you have struck up? Just you have struck out some sentence which was opening.
That's the right of respondent to a hearing in
Is now therefore in the full stop. Thus, it can safely be inferred that right of the appellant to right of the respondents so and so has been taken away. Then lying below, even otherwise, learned counsel for the appellant has stated that the appellant does not require the aforesaid land. Paragraph. That's it. For the aforementioned, in view of preceding analysis, we do not find any merit in these case and is hereby dismissed. Mr. Nataraj, Radhesham, library people, where it has been referred to. Yes. Is the judgment reported? Yes. Write down what is very good report. It's reported, Mr. SCC online. Thank you. So, paragraph. Far as learned counsel for the appellant has submitted, and learned before that do not find any merit. Before that, learned counsel for the appellant has submitted that since the appellant has utilized the land in question, therefore the relief be molded in the facts of the case. Full stop. From perusal of the photographs annexed with the petition, we find that the appellant has only, then don't write there, it will come. Appellant has only constructed a boundary wall and is dumping garbage on the land in question. Full stop. Therefore, the land in question measuring 3 acres and 3 guntas remains an open land. Therefore, the question of molding the relief and permitting the appellant to retain the possession of the land in question does not arise. That's the aforementioned reasons do not find. So when you have a good case, you speak only 3 sentences, right, Mr. Rajgopal? So necessarily, when you argue for more than 40 minutes, we will infer that you don't have a case next time. Yes. Yes, Mr. Naganan, which? Which one? 41? 42. 41 is done. 41 is done. Okay. Please supply. So when do you want? Who has filed? KIADB has filed objection. You are appealing for which respondent? You are appealing, Sagar. You are appealing for which respondent?
5 to 9. 5 to 9. 5 to 9.
4, 5, and 6. Mr. S.S. Nagaran. Mark everybody's presence. Mr. S.S. Nagaran, learned senior counsel for respondent number 4, 5, and 6. Praise for adjournment to seek instructions on the ground that KIA that he has been served with a copy of objections filed on behalf of KIADP recently.
Yes.
List after 3 weeks. What happened to 40?
Terms of time was disputed.
Right.
That was disposed of. Yes.
Other than 4.
We thought you want to argue something. You want to argue? Oh, how good. 55. Learned counsel for the appellant has moved the memo seeking permission of this court to withdraw the appeal on the ground that the dispute between the parties has been amicably resolved. Line below, the aforesaid memo is taken on record. Accordingly, the appeal is dismissed as withdrawn.
Number 43, Kalpana, PT Hegde.
40. What happened to 42? Here. Oh. Page 30. The ground is that therefore the chair left the room. It away.
Your husband has filed. Husband has filed a legal petition. Action files for registration.
Seven years after filing. So, madam, what is there at this point of time? Nothing.
Since how many years they are residing separately? Since how many years they are residing separately?
Uh, 19 years. You are living in peace, right? No. Yeah. It's 53 now. No. 7 years. 41. Not on the ground of delay, madam. So many other. What way in-laws were cruelly ill-treating her, not stated. No reason to withdraw the marital home for flimsy reason.
That doesn't mean that he was not interested.
This is Patna High Court.
Divorce petition filed by the husband was being rejected. Now I need to be, I need to stay with my husband. If he did not take me, I filed this petition to find him. You cannot dismiss the petition because I have not getting further evidence, not proof, by giving a notice to them.
On what ground the husband had sought?
Now that I am mentally ill.
That was a different ground. And you are seeking restitution, what ground? Where is your petition? You are seeking that you had a justification, right, of leaving the matrimonial home. That's what she said. That in-laws treated with cruelty.
And he did not take me to the matrimonial.
We cannot force a party to still having the ground of dissolution of marriage under section 13 may not be made out. But we cannot compel him to reside with you. How? What is like compelling, right? He doesn't want to stay with you. That's so obvious. You have to be practical, madam. 19 years, who can live? I mean, which husband, wife who are separated for 19 long years can stay together? No, not, there's no question of he's under an obligation to maintain you.
2003, sir. 2003 you have separated. Till 2010 you did not initiate section 9 petition. 7 years. What agitating? You never filed a petition. Then what does it mean? Then what does it mean? Then you should have initiated a proceedings. You can be initiate proceedings at any point of time. What is the husband doing? You have been awarded any maintenance amount? Filed a maintenance separately. Separately. No application is filed here.
Here,
Yes. Legal notice for what? The children born from the marriage? You are remarried. What's your instruction? Ma'am? Is he married?
Yes.
For cross-examination, you have suggested that he is remarried and has got children from. And then telling the judgment and decree dated 27th June 2013, passed in MC number 17 of 2010 by the Court of Senior Civil Court and Mercy Control. The application where the petition filed by the appellant under Section 9 of the Hindu Marriage Act 1955, seeking restitution of the conjugal rights, was dismissed. But it was not preparing for the parties and also parenting to that's leading to filing of this appeal narrated in brief of the marriage of the appellant. The respondent was organized on 2002 at the HSP House for aggravated and work as per the rights and custom that prevailed in the community. The marriage, the couple were residing together. The address shown in the past title for some time. Thereafterwards, the couple had the relationship between the couple was strained, and ultimately in the year 2003, the respondent, the appellant, had left the matrimonial house and started residing in a parent's house. The respondent hearing had filed a petition under section 1A of the marriage law. In MC number 36 of 2006, which was subsequently numbered as MC number 4 of 2007, on the ground that the appellant herein had treated him with cruelty after marriage. He said divorce petition was dismissed on 24/4/2010. After dismissal of the said petition, the appellant herein had filed petition under section 9 of the Act of 1955 seeking restitution of conjugal rights. And in the said proceedings, the respondent had entered appearance and filed a detailed statement of objection denying the petitioner in order to substantiate case of the appellant. He had examined herself before the trial court as PW1 and got marked 4 documents as a P1 to P4. Whereas the respondent had examined himself as RW1 and another witness was examined as RW2. He also got marked documents in support of his defense as exhibit R2, R1 and R2. The trial court widely included dismissed the section 9 petition filed by the appellant. The appellant has to but the appellant submits that the appellant was always ready and willing to join the appellant submits that clearly for the reason that the divorce petition filed by the respondent has been dismissed. The trial court was not justified in dismissing the application filed under section 9 of the Act of 1955 after dismissal of the divorce petition. She also submits that the appellant was under the impression that after dismissal of the divorce petition, the respondent husband would take her back, and therefore she had not filed a petition under section 5 earlier for control or not in support of her submission. She has relied upon the judgment of the Patna High Court reported in July 2014 Patna 114. But upon control council appearing for the respondent submits that appellant had left the company of the respondent in the year 2003 without there being sufficient reason. After a lapse of 7 years, he has initiated proceedings under section 9 of the Act of 1955. And there are no bona fides in the said petition. He submitted divorce petition was contested by the appellant, and only after dismissal of the same, he has thought it fit to initiate the proceedings. He also submits that for the past nearly 19 years, the parties are residing separately. They cannot be stay under a roof and live a normal married life. Accordingly, he has to dismiss your case. The undisputed facts of the case now. Marriage of the parties took place on 35/2002, and in the year 2003, the respondent, the appellant has deserted the respondent, and she has. The appellant has left the company of the respondent, and she started residing in her parents' house. Therefore, the respondent had initiated proceedings under section 1311A of the Act of 1955, seeking a decree of divorce against the appellant. Such proceedings, the appellant has filed a statement of objection denying the petition, and she has also contended that having regard to the harassment and ill treatment meted out on her by her in-laws, she was constrained to be the company of the she had contended that her in-laws had branded her as mentally sick. She was not in a position to stay in a matrimonial house. She was constrained to take shelter in her parents' house. In the course of cross-examination of respondent, MC number 7 of 4 of 2007, received by the appellant. It is in that it had suggested that the respondent has remarried and he has got children from the said marriage, and he was not willing to, therefore he was not willing to take her back. A criminal complaint filed by her against him? No. He go to that. Appellant had given a police complaint before the Surat police station against the respondent. And in the said proceedings, the respondent was summoned to the police station. since the attempt for a panchayat had failed. Police had what's the complaint and directed the parties to approach the court seeking dissolution of the marriage by petition, by filing appropriate petition. But it is not in dispute that the appellant has left the country of the respondent in the year 2003. And for nearly about 7 years, they have not filed any. She had not initiated any proceedings seeking restitution of conjugal rights, even though the respondent had initiated proceedings under section 13(1) of the Act for dissolution of the marriage by a decree of divorce. Parties are now residing separately for the last 19 years. Material record would also show that parties have a serious difference of opinion. And as a result, they have been fighting multiple. They have not only been fighting multiple litigations, they have also, but a police complaint is also filed against the respondent by the opponent. Circumstances we have to consider that no purpose would be served in asking parties who are residing separately for the last 19 years. It is also not in this that we will have no issues under the circumstances. Here of we considered that number the judgment of the in the judgment the Patna High Court petition filed for restitution of conjugal rights was dismissed, mainly on the ground that same was filed after the application for divorce was rejected. In case of petition has not been dismissed. Petition filed under section 9 of the Act of 95 by the appellant has not been dismissed by the trial court only for the reason that filed after disposal of the divorce filed by the respondent. Reading of the result of the judgment will go to show that. Right court has also done that. Parties have been deciding quickly for a prolonged period of time and for nearly about 7 years after separation. The appellant had not taken any steps for filing the restitution of conjugal right. The trial court has specifically contended that she was being ill-treated by her in-laws in a matrimonial house. And the trial court has even finding that there was no valid reason for the appellant withdraw from the marital home. Under these circumstances, the petition has been filed under section 9 Act of 95 as dismissed by the trial court. Therefore, the judgment of Patna High Court for which freelance has been placed by the Equivalence Council is of May 08. In case of the appellant, under the circumstances, we do not find anything in this. What will be same is dismissed.
Also, compromise, no. Compromise, no.
Last day, people need to seek information.
Ah.
The universal responsibility for our daughters. Is ready to pay amount of 5 lakhs.
In addition to that, what was the other proposal?
Other was, of course, the 5 lakhs.
5 lakhs to the mother. And in addition, additional 5 lakhs you are ready to pay to the for marriage expense. What is she doing? Daughter, what is she doing? Daughter. First PUC. First PUC.
Ah, yes.
5 lakhs for our education expenses and marriage, is it enough?
3 acres of land, right?
No, that is not.
You have immovable properties in addition to your income.
Daughter had made a submission that he is in contact with her and he visits her in the school, etc. That is the only time he has gone to see her. Or thereafterwards, he has not gone. That was in the year. Was it? Yes, Mr. What is your instruction? Not 498A. He is saying about that about the incident. 498A is for some different reason. Fact remains that he was tried for that offense and has been acquitted now. Because of all those things, probably after that he has not gone to the school. What is, what is, what is your instructions on the settlement? The restitution of conjugal rights, is there any stay? No stay. You are not sought any execution of the decree. Why not interested?
But different talks between his father. So, regard to that, because it's not initiated. Initiated that he might join.
On what ground this divorce has been sought? Huh? He has left 2008 is it? Why the mediation failed? They had left the matrimonial house in the year 2008. March 2008.
What lady?
March 2008, she has left.
If you,
Till 2007, she has not lived, only 2008. Where is that police complaint?
Complaint was on 10/11/2004, which was registered as NCR.
Where is that? Is it marked?
Page number 9.
Is it
Page
marked?
number 25.
Is the complaint marked?
This one. It was not right.
Huh? Exhibit? T20. 16/1/2013. It is dated 16/1/2013. 2011, there is one police complaint. Complaint, where is the first complaint?
Eleven of 2011.
Two 2013. Nothing to show she has deserted you for 2 years. There is nothing to show that she has deserted you for 2 years. What is that?
Legal notice, reply to the legal notice.
What she has said? It will. She has again asked you to take her back. She has asked you to take her back.
Stated that in March 2008, I'm taken on rent and then we live together for a period of 3 months.
Whatever it is, but this police complaint which has been lodged even prior to that, there she says only 4 months prior she has left you. That has come on record, and that complaint has been given even before this proceedings were initiated. We go by that. Only in the month of August 2011, she has left you. So far as cruelty is considered, there is no material. Assertion also, you are not able to prove that for continuous period of 2 years she has left you. What is the material?
Stating that when I took her back, it was all condoned because if you
What is that?
condoned violence. When I took her
Oh,
back,
you-
they say
Oh, let-
the honorable judges come to
Well-
conclusion that the same has been condoned violence, but it is a continuing act.
What is continuing, but what is that cruelty you have alleged? You was quarreling, etc. That's all.
Self legal notice, my lord, at the first instance, in the year 2011, stating that two legal notice has been sent, but a reply has been replied, stating that this is the
And even in the police complaint, the prayer made is that ಅವರನ್ನು ಕರೆಸಿ ಅವರಿಗೆ ಬುದ್ಧಿವಾದ ಹೇಳಿ. Even in the reply given to the legal notice, he was all along saying that she wants to join you.
instance, after the period of time, The first instance in the actually legal notice.
That for that only he has replied stating that he intends to come back. But you are not taking her efforts made in that regard also at failed, she has said. 2 times Panchayat was there. You have not agreed to take her back. What is the amount of this maintenance awarded? He has been paying regularly. Yes, anything else? We'll confirm it. There's nothing. Guilty is not established. So far as desertion is concerned, you have not proved that. What legal note? Material shows that for the continuous 2 years of period you were not separated. But the documents are will show otherwise. Her police complaint will show otherwise. That had come into existence even before your petition was filed. It's not overcome it. That came into existence even prior to your petition being filed. It's not to overcome. At that time you had not filed any petition seeking divorce.
Legal notice, legal notice, the file holds complaint that it's exhibit P21. It is legal notice, my lord. After that, only they have filed a police complaint on 10/11/2011, my lord. That is exhibit P21. To overcome this aspect, only they have filed a police complaint, my lord, stating that they are staying for a period of 3 months till 2011.
That cannot be believed. Even before you filing a petition, they have prepared their defense.
civil notice was issued on 15/7/2011.
That was not received by her. And one, for second one, she has replied.
To overcome this, they filed a police
What is that to
complaint.
overcome there? Nothing to overcome in a legal notice. What is there to overcome that?
To code of desertion manual that out of filing petition manual. But things are filing NCM manual, comment to advise of appealing to. Or as per the government, it was more than 3 years. We are leaving for paper.
Merits, also you don't have a case. In addition to that, you have got a grown-up daughter now. That's why we do not want to disturb the finding. Tomorrow she will be getting married. Therefore, not want to disturb the finding.
All right, anything else? Oh.
Lord, is it 52, my lord? 50, sir. Sorry.
Picture in the court will. The judgment has been passed granting the review on the ground which were stock in nature. And though during the course of hearing, the judgment offered to take her back, which amounts to washing away all the allegations. Here, he was not given any opportunity to application was filed to recall the order. That application without hearing the application, given only just adequate endorsement was made on the application stating that the application is hereby rejected. You will clearly see. Page number 63 of the.
You have not filed your objection before
This
the,
was directly applied before the lordship.
you have not filed your objection before the trial court.
Objection was not filed. Stating that because understanding was given to the applicant that will be settled, he will be taken back. Because academically, the husband has made a statement before the court saying that he is ready to take her back. She was wrong.
Content. No content.
When did you appear in the proceeding before the family court? When did you appear?
He was not placed ex parte. He appeared filed academic application seeking for permission of the court to engage in advocacy. That was allowed. But when an application was also
So when were you proceeded ex parte? Then
not file written statement because
your right to file written statement was closed.
he did not file. And accordingly, matter was closed. But
Why?
she was not given.
Why she has not filed?
Not filed.
Why?
Check was not filed because kindly see, she was given to understand that matter will be settled. And
Let him finish.
That's what we are asking. Please show us the order sheet.
Once it your lordship may kindly see.
Raj, I am not audible. It's on. On. Yes. It's on. No? Yes.
When did you appear before the trial court?
That is not telling. We have to see. Where is the order sheet, Mr. What?
I see page number 52. Thank you, Dr.
When did you enter appearance? When did you enter appearance, Mr.?
Hey.
10/1/2011.
Page number 30. But, 53. Then page number 54, at the bottom of the page, last of the kindly see. Petitioner counsel submits that petitioner is ready to take back the installment right to his house. That was the submission made before the court. That is why it was about to be settled. That was the understanding was given to her, and she was made to learn because she did not find any written statement or objection. Subsequently, what happened after this evidence was led by the husband without giving any knowledge about this to the wife, and she was not given the opportunity to cross examine because she had not filed the and application was filed as 53 or last 23. This is an application seeking for recalling the order and permitting her to file her objection. This IA was not contained. And without hearing and without considering the contention and reasons assigned for not filing, the court will write only a case is posted for judgment, question of reopen and recall does not arise, application is not maintainable, rejected. This is only order meant. She is having already said only son also development. Not considering all this. And moreover, an application for seeking for interim maintenance, that no order is passed on that application. She was so helpless, she did not even engage an advocate. Advocates were retired repeatedly and having no resource to contest and resist the petition.
He has not engaged any advocate. He had not engaged any advocate before the trial court.
Right?
He had engaged the services of an advocate. Why you say she has not engaged?
When the she orchard in harassment that contain that who will pick up the contention raised in the petition without considering the aspect that the wife was not having any opportunity. Simply on that, basing on that, the order has been passed on the grounds of cruelty and disrespect.
Petition is of the year 2010.
Yes, sir.
It was disposed of in the year 2015. 5 years it was pending before the family court. And you say opportunity not given. 5 years opportunity not given to you.
She was not aware.
What order?
15 September, she has withdrawn the file. The counsel is pleaded retired. The court should have
When is that, sir? 15?
15/9/2014. 15/9. Yes. Case paper NOC was handed over. Respondent granted time to engage another firm.
He was present.
Thereafter, she is absent.
Afterwards, she has engaged Nagaratnam. 26/11/2014. He engages another. 26/11/2014. Srimati Nagaratnam came, advocate 5.
5 cents. So no representation. Respondent's evidence taken as nil.
Human. 13 years son. And he has been taken care of and looked after by the appellant. Without considering all this, without making any provision for alignment And
No.
even
We don't know what sort of an argument, Mr. You are referring to an order sheet, right? My lord has asked you, it's not working, Mr. He is unable to hear. Case is pending for 5 years, and
Yes.
despite that, you say no opportunity has been granted. You are represented, you engaged the counsel, you took NOC, again engaged the counsel, thereafter remained absent. So what can be done? Why?
he was deprived of effective gains because of this.
Effective.
Any order of the interim maintenance was filed. Before without passing any order on an application, they cannot pass a final order. The provision is there for to enable the district to file. And yet that it is such case, even even signing any reason.
No. What did the council engaged by you did? Two councils were engaged by you. What did they do? The burden is everything, right? The court is always wrong. Fine. What did the councils do? Did they point out that the application is pending?
Application.
So, yes. What is the submission?
There is a gross coming to the conclusion as I think it order because it has taken only the conclusions are not based on any act or evidence. Only on the basis of the petition can be.
You don't file statement of objection, you don't cross-examine. And what should the court do? 5 years you have not done anything.
That is, I have not. Application family court.
Application file.
It has
What is
been-
the application
It
file?
has been dismissed. That application has been dismissed.
Yes, sir, that was dismissed.
It is dismissed. Then what is it?
No, that is why this given
There's no application.
the.
Doesn't say. Order sheet doesn't say.
Very clear market provider. This is not very.
What do you mean by contest opportunity ಕೊಡ್ಲಿಲ್ಲ 5 ವರ್ಷ ನೀವು ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಒಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 24 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ ನಿಮಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಒಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ವಾ ಅದೇ ಸೆಕ್ಷನ್ 24 application then how did you file your advocate could file a section 24 application he could not file statement of objection she has engaged not one she has engaged 2 advocates.
That was because of they did not handle this pick up the matter because of the inability to not pay inability to pay the fee. That is why application was filed for
That was dismissed, mister. You have not questioned it. That was dismissed.
Considering the application, into judgment was passed. At least even by passing the order, the practical aspect could have been viewed by the court below.
Have you remarried, mister?
You may you
Huh?
more submission.
Oh. Given relationship.
Having this marriage or subsisting my lord, he went to the respondent went to the extent of she has to reconcile that relationship, and he has to acquiesce that as a status of a co-wife. These were the demands.
What are you doing? What are you doing? Now what are you doing?
Software.
You were a software engineer. Now what are you
remain a
doing?
software engineer, right?
Now nothing. Now you are not doing anything. Now you are not doing anything. No income.
No. And he
Your party is ready to accept any. Your party is ready to accept any permanent aluminum.
Yes, because she says that
Yes. Yes. Now,
let there be a date may be given, but after there be a date, so that let both the parties be present.
no mediation and all, no mediation and all. Tomorrow, get instruction from your party. No mediation for this. Why mediation? Yes.
By next week, tomorrow.
Find out.
Okay, what?
File an affidavit of assets and liabilities. It is Thursday. Wednesday, we'll keep it on Wednesday. Wednesday. File a affidavit with regard to your assets and liabilities. Wednesday or Thursday? Thursday.
Need counsel for respondent. Pays for short accommodation to enable him to file a statement of assets and liabilities. Affidavit pertaining to statement of pertaining to assets and liabilities. Yes, 10th November.
You also file.
Parties.
Both. You also file.
Correct.
You are also required to file, mister. You also file.
Parties.
Thursday, both of you have to file.
10th.
Associates. Praveen Kumar.
Sure, password.
Shani Agre.
52, I am my lord here. My lord, I am the appellant in this case. Am I audible, my lord?
Yes.
My lord, after having married in 93, we have got a daughter born in 1995. Somehow there has been no compatibility between us, and we filed a joint petition 490 of 2011 seeking divorce. That is Annexure B, which I have produced before your lordship. My lord,
I may make one submission, please, Your Lordship.
my lord, in this case, after having filed the joint petition, she does not agree to sign in the open court. So therefore, I had to file a divorce petition.
Sir, counsel for respondent praying for time, sir.
My lord, she is permanently residing in Canada. My daughter is also major, 28 years old. And I have been languishing right from 2008. My lord, 2008 I have been languishing. My lord, the previous lordship directed them to produce the passport also. She is permanently...
Respondent wants to say something.
Okay.
Please wait.
Please.
Listen to her what?
It's a petition of 2008. It is separate since 2008. Even in his petition, he claims that he has no responsibility to look after the wife or the child. This is what he has claimed. And he says that she is well placed, and as usual, he is not doing it. Without elucidating the luxury of Helen, I would like to save the report, the time. If your lordship would clearly tell it, he has to pay some maintenance for the, I'm not asking, right? Doesn't want to pay. As a father, if he could make some deposit in favor of the daughter, it matter to be pleased.
All right.
Did you hear it, Mr. Ravi Kumar?
My lord, with great respect, it was not fully audible. My lord, I should not trouble your lordship. I do not know why the adjournment is.
Probably that monetary aspect was not heard by you.
My lord, monetary aspect as per this court's direction. No, my lord. On 18/8, my lord, as what was directed, it was ordered. And my lord, his lordship Jayant Patil directed by then, during the pendency of the trial court matter, she left India in 2012.
Are you ready to pay any amount?
My lord, what is it? I am without a job. She is permanently, safely, comfortably settled in Canada.
I want money from you.
My lord, I was doing my event management. Due to Corona, I lost that one also.
Ah, yes.
I have,
So it should maintain you, right?
no,
Your
I will
wife-
not say, no, my lord. I will not expect her to maintain me. I will beg
Ah,
or borrow. My lord, I am son of a defense personnel. My lord, I studied in military school.
It's not working.
My lord, I am unable to get a lucrative job. Certainly that.
I don't know. You have a daughter and you have a
My lord, she
responsibility
is today
towards her.
married, my lord. I am given to inform, she is 28 years old. She left when she was major.
No, so were you present in our wedding? What did
She
you
never
do to-
called me, my lord, no, because I got the information by now she is settled in Canada. I was not informed.
What to, he will not do anything. We will have to hear it on merits. What? He doesn't.
My lord, I don't possess anything to give to my,
He is a pauper surviving on thin air. He is a pauper. Doesn't know. He doesn't have anything. No question. We don't intend. We'll deal with it on merits. What can be done? You have seen what sort of person he is. Not prepared to take care of his daughter. Also, what can be done?
I wanted the custody of my daughter after she was here in India. She deprived me to have the custody also, my lord. I could not nurture an Indian culture.
Now she is not asking any money. She is asking money only for the child.
My lord,
For your
my
daughter.
child is also settled.
You can pay, even if it settles, you can pay.
My
No,
lord,
you
if
are
she-
the only person
my
not
lord,
settled, right?
if
in
she comes
life.
if she comes to India and tries to, if she is unmarried, well, look here, I will take care of her marriage also. No problem.
Your daughter is settled, wife is settled. You are the only person who is still not settled in life.
Because of her. Because of her. Because of her, my lord, I am in agony. And I don't want to get remarried. That's a different thing. I am 40 plus. But certainly one thing, all these years, 12 years, my lord, we have been living
He
separately.
had filed a petition seeking dissolution of marriage
Yes,
on the ground cruelty.
desertion. No, on the ground of desertion. And admittedly, there is a desertion. She left India on her own volition. Along with the daughter, without my permission.
Your petition has been dismissed. You have been directed to pay maintenance to the wife and child.
That I have paid. That is the order. That is the order dated 18/8, wherein I have complied the order till it was paid, because by which time she was already in Canada. She has taken permanent residency. She has not produced any passport, my lord, of her citizenship there.
You can also go to Canada. They are
My lord.
offering 1.5 lakh new jobs to
My lord,
Indians, everyone, right?
Mera desh
New
mahan.
immigration policy.
No, I would like to live in my desh, my lord. I would like to live and die here.
Oh.
Why should I go when my country is more cozy for me?
No, you are not getting a job here. That's why we said.
No, it's not
All
like,
right.
my lord. I am not begging. I am certainly doing sundry jobs. like event managements, wherever I am getting in a paltry thing, virtually on a daily wage basis. I am certainly not begging on streets.
You said that you are not doing anything.
My lord, I was doing event management. Today also, I am trying to do sundry.
Mr. Argue, this all irrelevant. Argue the petition on merits, whatever you will.
Yes, madam. But so
So,
far as
madam, not possible. What can be done? Not possible. You have seen his attitude. Why let him argue? We will affirm the judgment. What if we don't agree with him? We will affirm. Let him. Better to get out of this. Before he claims maintenance from you, better to get out. Hey, you people don't enjoy the humor also, right? I mean, so serious. What is there? What is those? Look at him. He's looking like us like a tiger, ready to pounce. What is there? It's an appeal, right? You don't enjoy humor also.
no, I am enjoying, my lord.
Not enjoying. You are not enjoying.
No, educative humor.
You look like, you should sit here, look like a tiger ready to pounce on us. You are looking like that, so dangerous and ferocious.
No, my lord, I am born with such a face. I do not know if my face is ferocious. If my face,
that's the humor which you don't enjoy.
I am really enjoying it, my lord. What
Good,
I would
good,
like,
good.
no.
She doesn't want to contest. She wants to get out of this marriage. File an application under 13B, madam, petition. Mutual. Your wife is ready for dissolution of marriage. You also seek instructions and you jointly make a statement.
My lord, it is for my learned friend's claim to know. My learned friend should be in a position to tell where she is. Otherwise, she should consent for the divorce, whatever I have sought here, my lord, in this appeal. My lord, she is not coming from Canada. She has not come.
You want a divorce, she is ready. That's it. She wants to ascertain, right?
She wants a confirmation.
Okay. So we'll take it up tomorrow. Tomorrow, Mr.
Obligement.
It will be in the list. Tomorrow we will take it up.
Please, man.
You please better to get out of this. And before he makes a claim on your this thing for maintenance, better to get out of this.
Number 53, Advocacy decide.
Don't have 5. Have. So
And why you want to press this?
Permanent alimony should be paid.
3 lakhs.
3 lakhs only, madam. Oh. It's for her to take recourse to such a remedy, but what is there? It's not, it's the most reasonable amount. It should be enhanced rather, in our opinion. She should have filed an appeal. Lakhs is, madam, more than reasonable. 3 lakhs permanent alimony is more than reasonable. We don't want it. Let him face the music. He's in jail. He will.
Anyhow in jail.
Nothing. Jail, immune from everything, enjoying life. So let him enjoy. Once he comes out, she will execute the decree. Whatever happens will happen. He will again go back. What's there? He is now accustomed to living in jail. In execution of the decree, he has nothing. He will go once again to jail. What will happen? So, that is no defense, madam. Why did you marry? If you had no means of income, why did you marry? What did you tell her at the time of marriage? That I have no means of income, despite that she married. Huh? What is sort of an argument? Acha, oh, this my lord is right. You married because she was a permanent employee. Huh? That's right. You told her that I don't have any means, I will be dependent on you. Huh? Nothing, madam. Matrimonial, this is no defense, madam. Dispute between 100, if you treat, is it not an offense? 498A?
307, sir.
Oh,
He stabbed her.
307. Then dispute. So madam, this is no defense. This is no defense. Frivolous. This is no defense. He has no source of income. We are not going to accept this. No source of income. Even then he is supposed to earn for his wife. The Supreme Court has said recently, right? Recently, madam, Supreme Court has said that even if a person, if you are an able-bodied person, not physically challenged, you have to do something and earn and maintain your wife. This is no ground. We cannot put premium on your this thing. And nothing. Why did you not file an appeal? That's fine. Even if he works under that Manrega scheme, you would how many 500 per day? Even if you want this thing, work under this employment guarantee scheme, you will get 500 rupees a day. What is this? Employment guarantee scheme is there, no?
Is there?
Work under an employment guarantee scheme. You will learn if you are unemployed. Nothing matter. There's no argument. Fine. No. So therefore you will try to kill her. Huh? And because she is earning. No, nothing. You have been convicted, madam. And that's not the subject matter of this appeal. Your only argument is he has no source of income. He is an able-bodied person. He is supposed to earn. We will not this thing accept this submission. No source of income. Let him remain in jail if he has no source of income. Let him remain. We have no sympathy for such people. Nothing. No adjournment. No. We know that law. Do you think that we have become judges without knowing that law? That on the basis of, we are accepting this, that on the basis of status of parties. That's why only 3 lakhs has been granted. She ought to have filed an appeal. We would have enhanced it to 15 lakhs. Nothing. Fine. Thank you. That's all. Right now, mark the presence.
7 stab injuries.
Ask him. Madam, 7 stab injuries and you are saying a dispute between husband and wife? Huh? The dispute takes place with a knife between husband and wife. 7 stab injuries. Not good. Very good. You are unfortunate that she survived. This appeal under section 19 within bracket 1 of the Family Courts Act has been filed against judgment dated 2nd of May 2015 passed by the Family Court, by which petition filed by the appellant under section 13(1) within bracket small Roman 1 hyphen dash a, no, not hyphen a, small a bracket close of the Hindu Marriage Act has been allowed, and the by which petition filed by the respondent, under section so and so of the Hindu Marriage Act has been allowed, and the marriage between the parties has been dissolved by a decree of divorce. Paragraph facts giving rise to filing of this appeal briefly stated are that the marriage between the parties was solemnized on 13/5/2003. Full stop. The respondent filed a petition seeking dissolution of marriage under section 13 small a 1 of the so and so on the A and B. A and B of the Hindu Marriage Act on the ground of cruelty and desertion on 20th March 2014. Full stop. The appellant contested the proceeding. The family court wide judgment dated 2/5/2015 dismissed the petition insofar as it pertains to the ground of desertion under section 13(IB) of the Act. However, the marriage between the parties was resolved on the ground of cruelty as enumerated under section 13(IA) of the Act. Full stop. In the aforesaid factual background, this appeal has been filed. Paragraph. No, before that, dissolved and a permanent alimony of rupees 3 lakhs has been granted. Permanent alimony of rupees 3 lakhs and rupees 20,000 litigation expenses have been awarded to the respondent against the in the aforesaid factual background. This appeal has been filed. Paragraph. Learned counsel for the appellant submitted that in pursuance of the complaint filed by the respondent, a complaint was registered against the appellant for offence under section 307 of the IPC, and the appellant has been convicted and is sentenced to undergo rigorous imprisonment of 7 years. It is further submitted that the appellant is undergoing the jail sentence presently. It is also no, before that, it is further submitted. It is further submitted that aforesaid conviction has been affirmed by a bench of this court, and the appellant is presently undergoing this jail sentence. Full stop. It is further submitted that appellant is not aggrieved by the decree granted for dissolution of marriage However, the appeal is confined only, however, the grievance of the appellant is only confined in respect of the judgment judgment and decree insofar as awards a sum of rupees 3 lakhs by way of permanent alimony. It is urged that the appellant is unemployed and has no means of income. On the other hand, paragraph on the other hand, learned counsel for respondent has supported the judgment and decree passed by the family court. Paragraph. We have considered the submissions made by learned counsel for the parties and have reached the record. What was he doing? What was he doing with this? The appellant. The appellant was an employee. Appellant was serving Karnataka Power Transport Corporation Limited on contract basis. On contract basis. It appears that he has lost his job. However, the fact remains that he is an able-bodied person. No challenge. So what?
It appears that he has lost his job.
That appellant is an able-bodied person and is under a legal obligation to maintain his wife. Full stop. From perusal of the prayer clause of in the memo of appeal, we find that the judgment that no challenge has been made to judgment and decree insofar as it grants permanent alimony for a sum of rupees 3 lakhs. Full stop. By any standard, the amount of permanent alimony granted by the family courts is a moderate sum. In the facts and circumstances of the case, in our considered opinion, no interference is called for with judgment and decree insofar as it directs a modest sum of rupees 3 lakhs by way of permanent alimony. Paragraph. Discovered in the result, appeal fails and is hereby dismissed.
It's not very. Appeal memo.
This is what, which case, Mr. 53. Yes.
Number 54, Christopher Noyer, the young Israeli right.
Mail would have reached him, right? He can respond to you. Why Monday? He takes 3 days to respond. Then he can respond, right? He doesn't check his mail. Yes, madam. Oh. No, I will. So the burden is on us, right? Huh? No, you better argue. Forget about what is it. Whatever will happen will happen. If a person is unresponsive, he should suffer. Why should you worry? If your appeal is dismissed, let him be happy. As it is, he is happy. Wait, let it continue in the list. Tomorrow we'll take it. Why? You shouldn't have been bother about persons who are not responsive. Not interested, he will face the music. What's there? Yes. What is 56? 55 is done, right? Disposed of. 56.
56, the G.R. Mohan, Sampath Anand Chetty, Abhinav.
Yes. What is it? Huh? Adultery. Appellant is what? Wife. Okay. Yes. Yes. Where is your counsel, madam?
ನಾಳೆ ತಗೊಳ್ತೇವೆ ನಾಳೆ.
Come here near the mic.
ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಎಷ್ಟು ದಿವಸ ಬೇಕು? 1 ತಿಂಗಳೆಲ್ಲ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲಮ್ಮ. ಇದು 2015 ಇದೆ, ಅಪೀಲು ತುಂಬಾ ದಿವಸದಿಂದ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. 1 ತಿಂಗಳೆಲ್ಲ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ. ಅದೆಲ್ಲ ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ. ನಿಮ್ಗೆ ಎಷ್ಟು ದಿವಸ ಬೇಕಂತ ಹೇಳಿ ಅಷ್ಟೇ. 1 ತಿಂಗಳು ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ. ಮ್ಯಾಕ್ಸಿಮಮ್ 1 ವಾರ ಟೈಮ್ ಕೊಡ್ತೇವೆ ನಾವು. ಅದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್. 2015 ಕೇಸ್ ಇದು. ನಿಮ್ಗೆ ವಕೀಲರನ್ನ ಇಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ, ದುಡ್ಡು ಇಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಲೀಗಲ್ ಅಸಿಸ್ಟೆಂಟ್ ನಾವೇ ಕೊಡ್ತೇವೆ ನಿಮ್ಗೆ. ಫ್ರೀ ಲೀಗಲ್ ಏಡ್ ಕೊಡ್ತೇವೆ.
List. Appellant in person. Person states that she may be provided legal access, legal aid. She may legal aid. In view of objection submission. 3. Venkatesh P. Dalwai. Advocate is appointed as in the Micus, not the Micus.
Legal service.
Is appointed as an advocate for the appellant. Office is directed to reflect his name as counsel for respondent. Line below registry is directed. Will supply him papers. Yes. Registry shall supply him the papers. List on 21st November. 21st November.
21/11.
So you tell Mr. Dalwai, right? That he has been appointed and he should appear.
Phone number.
That's it. Until somebody wants to withdraw. Yes, Mr. Patil.
Serial number 63. Tomorrow and day after I have some difficulty with it, and it will call next week. 63.
Yes. Who appears for responding? You are for the appellant. Mr. Jay Kumar Patil, senior counsel for the appellant. Learned senior counsel for the appellant, prays for short accommodation. List in the next week. 63. Interim order, if any shall come. You want to argue? You want to argue, right? What's the time? Nothing. He will assist you in preparing the case. Government advocate, right? You assist him tomorrow.
Okay.